In this video, we'll look at the UCC's firm offer rule as codified in Section 205 of Article 2. Firm offers provide a method for one party, the offeror, to make an irrevocable offer. Firm offers under the UCC build on the idea of an option contract from the common law of contracts. Recall that at common law, offers are irrevocable at any time before acceptance. That is, even if the offeror promises to keep the offer open for a specified period of time. For example, I offer to sell you my car for $1,000 and say that I'll keep the offer open until Friday. That offer may be revoked unless it qualifies as an option. An option is an offer in which the offeror promises to keep the offer open for a specified period of time, and the offeror's promise is supported by consideration paid by the offeree. So, for example, in exchange for my promise to keep my offer open until Friday, you, the offeree, pay me $50. There are good reasons an offeror might want to make an irrevocable offer like this. It gives the offeree time to investigate and consider the offer, making it more likely the offer will be seriously considered and perhaps accepted by the offeree. But an option contract requires the formality of bargained for consideration. The UCC does not eliminate the formal requirement of consideration to create option contracts. Instead, Article 2 provides an alternative or different method to make irrevocable offers, and that's provided in Section 205's Firm Offer Rule. Section 205 provides as follows that an offer by a merchant to buy or sell goods in a signed record, which by its terms gives assurance that it will be held open, is not revocable for lack of consideration during the time stated or if no time is stated for a reasonable time. This provision gives us a good opportunity to practice the skill of statutory interpretation. In particular, what does this statute require exactly to make a firm or irrevocable offer? There are four basic requirements for a firm offer. First, the offer must be made by a merchant. The first question you should be asking yourself when you see this word is, what is a merchant? This is our first encounter with merchants, and it's a recurring concept that you will see used throughout Article 2. Article 2, Section 104, subsection 1 defines merchants as a person who deals in goods of the kind or otherwise by her occupation holds herself out as having knowledge or skill peculiar to the practices or goods involved in the transaction. Essentially, the basic definition that we could use for now is that a merchant is someone who deals in or otherwise has expertise in the type of goods or business involved. As we'll see, Article 2 provides special rules that apply only to merchants, such as Section 205's Firm Offer Rule, which specifies that only merchant offerors can make firm offers. Second, 205 requires that the offer be made in a record. Again, when you read this word, the first question you should be asking yourself is, what is a record? Like merchant, record is a recurring concept that's used not just in Article 2, but in fact throughout the entire UCC. So, it will be important for you to understand and remember what we mean by record when you see that word used throughout your study of the UCC. Fortunately, like merchant, the UCC defines record for us. It's defined in Article 1's definition section, 201 of Article 1. And the definition provides that a record means information that is inscribed on a tangible medium or that is stored in an electronic or other medium and is retrievable in perceivable form. Stated differently, a record means any writing, whether that writing appears in a physical, tangible form, like a paper document, or in electronic form, in email, text message, or the like. In short, record means any writing. In fact, you will often hear the words record and writing used synonymously in the context of the UCC. To help you remember this, if you see the word record in the statute, just think of writing, whether that writing is memorialized in tangible form or in electronic data. The third requirement for 205 is that the offer must be signed by the merchant offeror. Note here that signed is also a defined term under the UCC, again defined in Article 1's definition section. And note here that the definition of signature is more broad than simply a handwritten signature that you might scribble on a physical document. Signed means with the present intent to authenticate or adopt a record, to execute or adopt a tangible symbol, or to attach to or logically associate with the record an electronic symbol, sound, or process. Stated differently, any symbol, whether tangible or electronic, that one might use with the intent to authenticate or adopt a writing or record is considered a signature. That would include a handwritten signature, but it would also include a name printed at the end of an electronic document or an automatically generated email signature at the bottom of an email. Anything, any symbol used to adopt or accept a writing is considered a signature under the UCC. The final requirement of 205 is that the signed writing must give assurances that the offer will be held open. If the offer meets these four requirements, then the offer cannot be revoked for the period of time specified in the offer, or if no time is specified, within a reasonable period of time. Now, what is a reasonable period of time? That depends entirely on the context and circumstances, the types of goods involved, the nature of the transaction, and so forth. What is clear is that a reasonable period of time can in no case exceed 3 months. That is, even if a written signed offer explicitly says that it will be held open for longer than 3 months, under UCC Article 2, Section 205, a firm offer may be revoked after 3 months. If an offeror wishes to make an irrevocable offer that is to be held open for longer than 3 months, she simply cannot make use of 205. Instead, she must use the common law's option contract, where her promise to keep the offer open is supported by bargain for consideration by the offeree. So, to summarize, in this video, we looked at how Article 2's firm offer rule provides parties an alternative route to make irrevocable offers to purchase and sell goods. In the next video, we'll look at one of Article 2's most vexing provisions, Section 207's Battle of the Forms.